Counsel?
Mr. Chief Justice, and may it please the Court, my name is Rael Papke. My co-counsel Matthew DeMay and I represent the petitioners in this case, the Olympus Department of Social Services and the child welfare worker Samantha Summerman. Your Honors, when the interests and welfare of dependent children are at stake, this Court has ruled that those needs are to be considered paramount and not to be relegated to secondary to what a mother considers to be her rights. There are two constitutional issues before the Court today. The first concerns whether Ms. Denolf's or Ms. Summerman's search of the home is a violation of the Denolf's constitutional rights, and the second concerns the issue of qualified immunity. I will be addressing the first issue, after which my co-counsel will be addressing the issue of qualified immunity. My client, Ms. Summerman, has not violated the respondent's Fourth Amendment rights for the following three reasons. First, because the Denolfs have a lowered expectation of privacy due to the ongoing supervisory relationship established by the receipt of state funding. Second, areas of lowered expectation of privacy are governed by the special needs doctrine, which balances the need to search against the invasion which that search entails. And third, because our need to search is at its absolute zenith, and the invasion of that search is minimal, or the invasion of that privacy is minimal. First, the Denolfs have a lowered expectation of privacy due to their chosen ongoing supervisory relationship. Where there is an area of lowered expectation of privacy, the special needs doctrine governs in that area. According to this Court's decision in Griffin v. Wisconsin and New Jersey v. TLO, the special needs doctrine governs when special needs beyond the normal need of law enforcement make the warrant and probable cause requirement impracticable. This Court has deemed the special needs to be present in areas of reduced expectations of privacy. Areas of reduced expectation of privacy are considered to be those in which there is an ongoing supervisory relationship. The case before the Court today is much like that in Griffin v. Wisconsin and New Jersey v. TLO, as the Griffin Court noted when patterning their reasoning after that in New Jersey v. TLO. The Griffin Court said, as was true then in O'Connor v. Ortega and New Jersey v. TLO, we deal with a situation in which there was an ongoing supervisory relationship, and one that is not, or at least not entirely, adversarial between the object of the search and the decision maker. So in this case, Your Honor, we have a probation case before the Supreme Court in which they align themselves with a case that dealt with a public school, saying that the similarity was in the ongoing supervisory relationship into which each had entered into.
What's the ongoing supervisory relationship in this case?
In this case, Your Honor, the Denolfs have agreed to receive federal funding in exchange for allowing the state to maintain annual records regarding the health and welfare of their children. There's an ongoing supervisory relationship between the state and the Denolfs as it regards the health and welfare of their children.
It only requires a certification from the doctor relative to the visit and the good health of the children. Does it also include the right to conduct strip searches of the children?
Your Honor, it is not clear in the record what the specific requirements were in that particular circumstance, but what we do have is they are...
I think it is. I beg to differ with you, Counsel. It specifically says that the letter, if I can find it quickly, the letter alleged that Mr. Denolf was over... where is that, about the medical? Social workers, okay, had agreed to provide DSS with annual proof that the children had been seen by a physician and were in good health, period. Not to go into the home and inspect the home, and not to certainly not to strip search the children.
But their failure to provide that information is essentially a broken contract. They broke the contract to which they had gone into with the state, and the state, as in taking upon themselves the responsibility, or not taking upon themselves, but exercising their given responsibility. Do you have a question, Your Honor?
Yeah, I'm wondering how a broken contract gets them into the house.
In this case, Your Honor, it is reasonable suspicion. As I will go on to tell you, in exercising a special needs doctrine, according to New Jersey v. TLO and Griffin v. Wisconsin, they are, in a special needs case, they are able to enter upon reasonable suspicion rather than a level of probable cause. And the reason for this is that you cannot, in those special needs cases, obtain a level of probable cause. So instead, on reasonable suspicion, they enter, and according to those courts, it is a lower quantum of evidence than probable cause, but still a certain standard of quantum evidence.
So,
Go
ahead.
Oh, pardon me.
What was your reasonable suspicion then?
In this case, Your Honor, we have the reasonable suspicion first in the letter, and second in the reports of the neighbors. The reports of the neighbors.
Conflicting neighbor report.
Your Honor, in fact, they were not actually conflicting in this instance. We have one neighbor that alleges that Lucy was constantly running around without her clothes on. To that, the other neighbor never gave a response or an answer. We also have the fact that the father was overly affectionate towards his daughter. And the good opinion that the one neighbor had of the father's action in that circumstance, the excuse was told to her by Mr. Denolf himself. It was Mr. Denolf that said that she ran outside because she saw a dog in the yard. But the other neighbor did not actually see that, and her good opinion actually came from the man under suspicion himself. So in this case, the ongoing supervisorial relationship can be entered into by receiving welfare funds or adoption subsidies. The James acceptance of government funding in the case of Wyman versus James reduced their expectation of privacy. This was instructively noted in Roe versus Texas Department of Protective and Regulatory Services in the statement, in Wyman and Griffin, the search persons voluntarily surrendered a great deal of the privacy interest in their homes. Thus, an ongoing supervisory relationship creates a reduced expectation of privacy and can be entered into by receiving government funding and its conditions. In the case at bar, the Denolfs have submitted themselves to the same type of ongoing supervisory relationship. The Denolfs have agreed to submit their children's annual medical records to the Department of Social Services in exchange for $1,258 a month in county adoption subsidies. Medical records are extremely private. They are among the most private documents that an individual can have.
It's not medical records, though, counsel. Don't stretch the facts.
I'm sorry.
It's a certificate that they've been seen by the doctor and that the children are in good health. That does not mean all the medical records.
I'm dutifully corrected. Thank you. The special needs doctrine, then, once we have a lowered expectation of privacy, and granted it's not that much of a lowered expectation of privacy, but once we have that lowered expectation of privacy, we move on to the balancing test. In this case, in New Jersey, in the discourse...
Can I ask, are we saying that we're looking at the lower expectation of privacy on the, with regards to entering the home? Are we at all arguing exigent circumstances, or what? Is this an administrative search? Is that what you're telling me, or is it what type of search are we dealing with here?
Your Honor, what we're arguing before you today is new, but it's not novel. In this case, we have a case like this has never come before the Supreme Court before today.
I'm just asking, just for clarification. Maybe I wasn't clear. Is this an administrative search or not?
It is not, Your Honor.
Okay.
It is not an administrative search in the sense that we have in Wyman versus James. And the reason why it's qualified as that is that in Wyman versus James, you have a different type of circumstances surrounding that search. In special needs cases, which administrative searches fall under the special needs exception to the Fourth Amendment, administrative searches are generally more random. They're like traffic stop cases, and they're entries into the public schools where you simply look at all of the children and test them for drugs. A special needs search, on the other hand, in Griffin versus Wisconsin and New Jersey versus TLO, has a level of suspicion. And in those cases, you enter upon a person's private property on the basis of reasonable suspicion. So
the TLO case was dealing with a public school, was it not?
yes, Your Honor, it was. So once again, what it is what we're arguing before you today is new, but it's not novel, in the sense that this has never come before the Supreme Court before, a similar case. But we do have the reasoning in New Jersey versus TLO, a public school case, Griffin versus Wisconsin, a probation case, and Wyman versus James, which specifically did address social worker entry into the home, but under the context of an administrative search. So if we put together the fact that all of these are governed by the special needs doctrine in an ongoing supervisory relationship, in Wyman, they did not address a situation where the children, or where there was any allegations of any kind of criminal activity or any kind of wrongdoing. So Wyman versus James didn't actually address this question. We don't know what would have happened to the James if there was any sort of wrongdoing on their part. What would have been done if they were alleged to have committed some kind of criminal or wrongdoing against their children. In this case, Your Honor, we are dealing with something new, and we have the reasoning that allows us to get to the position that we need it to be, which is that this falls under the special needs doctrine of the Fourth Amendment. So what
Why was a warrant not obtained? There was a 24-hour period that we're concerned with here, approximately 24 hours. Why was a warrant not obtained?
Because a warrant requires probable cause, Your Honor. In this case, a warrant injects seriously objectionable features into the... My time is running out. May I please finish?
Finish your answer.
In this case, Your Honor, a warrant injects seriously objectionable features, and not only that, but it requires that you have secondary sources and secondary sources to back it up. In this case, Your Honor, we advocate reasonable suspicion and that you balance the need to search against the invasion which that search entails.
Thank you.
Thank you.
Counsel?
Mr. Chief Justice, and may it please the Court, my name is Matthew DeMay, and as co-counsel for the petitioner, I'll be addressing the issue of qualified immunity on behalf of Ms. Samantha Summerman. This is a suit for damages against a government official acting in her proper role as a child welfare worker. As stated in Harlow v. Fitzgerald, the primary purpose of qualified immunity is essential to protect government workers for the fear of litigation in the exercise of their duty. As stated by this Court in Anderson v. Creighton, qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. Saucier v. Katz by this Court laid out a three-part test that is used by this Court to address the issue of qualified immunity. First, was a constitutional right violated? As my co-counsel has clearly laid out, we do not believe that a constitutional violation has occurred, but for the sake of argument, we must assume that one has before we move to the issue of qualified immunity. The second...
Isn't a warrantless search, isn't it presumed to be unreasonable?
Well, Your Honor, it's true that a warrantless search is presumptively unreasonable, but the Court has laid out a number of very specific exceptions, including the special needs search, which we believe that this falls under.
But in your analysis, don't you have to start with the presumption that the search is unreasonable?
Not in a qualified immunity case, Your Honor. In a qualified immunity case, what we must start with is the presumption that the right is not clearly established, and then it must be found that the right, that all of the contours of the right involved are clearly established before the government official can be denied qualified immunity. Now, the three-part test, again, moving to the second part in Saucier v. Katz, was the law at the time of the violation clearly established? In this case, we do not see that the law at the time of the violation was clearly established in the absence of clear Supreme Court precedent and because of an inter-circuit conflict noted in Roe v. Texas Department of Protective and Regulatory Services. Finally, the final part of the test is, could a reasonable officer have believed that their conduct was lawful? And there's a very important part of the test that's laid out here in Saucier v. Katz, because if you believe that a reasonable officer could have believed that it's lawful, then that officer must receive qualified immunity. Let us first look to whether the law at the time of the violation was clearly established.
Would an officer believe that a bodily strip search is reasonable?
Yes, Your Honor. There are a number of reasons and a number of cases in the record that would lead an officer to believe that. One of the most clear ones is Easy v. Kohler, where we have a very, very similar situation to what we have here, and where the court laid out, where the district court laid out by using the Supreme Court's reasoning in Wyman, that this was a proper search, mainly because they said the price of even one child is too high to pay to say, well, there should be a greater expectation of privacy here than there usually is.
How many of these cases have decided a strip search by a social worker?
Well, Your Honor, the Easy v. Kohler has decided that. Also, Darrell H. v. Kohler, which is cited several places, including Calabretta and Roe, that was another case that said a strip search was acceptable by a social worker. So the record is certainly not bereft of cases that say and still say that this sort of thing is certainly acceptable. Now, when we look at the inter-circuit conflict, Roe v. Texas Department of Protective and Regulatory Services specifically notes that there is basically a war between the circuits on this point. They said, we have not addressed which Fourth Amendment test should apply to a social worker's visual search of a child's body cavities, which is what occurred here, and the other courts of appeals are divided. The Seventh Circuit has held that a Child Protective Services need only satisfy the lesser special needs test, not the more rigorous probable cause requirement. This is what we are arguing. The 3rd, 9th, and 10th Circuits have rejected the 7th Circuit approach and instead applied the traditional 4th Amendment standard to juvenile strip searches. The 2nd Circuit has taken an intermediate position. Now, in the Roe case, they say, well, we're going to take sides here, and because of the way we interpret the Supreme Court case, like the recent ruling in Ferguson, they say because of the way we interpret that, then we're going to come down on the side that says that it's traditional standards, not the special needs side. However, by that circuit court saying that they are taking a side, that it goes without saying then that there are two sides to be taken. And to say that taking the other side is unreasonable would be to say that the 7th Circuit is completely unreasonable, that the dissent from the 17th Circuit is completely unreasonable, and that all these people are just looking at the cases in a completely wrong way that you couldn't possibly interpret. That's the standard laid out for qualified immunity. And since there are clearly two sides in this conflict, then that's why we believe that Ms. Zimmerman must be granted qualified immunity in this case. Now, when we look at the third point, could a reasonable officer have believed conduct was lawful? Again, with my co-counsel's arguments, this court does not have to rule.
Are we talking about a reasonable police officer standard here? I think the standard is a reasonable person, and it'd be a reasonable person in this position of a police officer as opposed to a reasonable person in the position of a social worker.
Well, Your Honor, by reasonable officer, I merely meant a reasonable officer of the government, not specifically a police officer. And it is indeed the reasonable person standard, but it has to be a reasonable person with the knowledge of the case law. Now, when we look at a reasonable officer in this standard, as with my co-counsel's arguments, this court does not necessarily have to rule that my co-counsel was correct in her interpretation of the special needs doctrine for Ms. Zimmerman to be granted qualified immunity. All this court has to ascertain is if my co-counsel's arguments are reasonable and a way that the law could be interpreted, then Ms. Zimmerman must be granted qualified immunity, for she could have interpreted the law in the exact same way as any other reasonable person.
This brings me back to the full circle to the question I asked you before. Mm-hmm. Would the social worker standing in the position of a reasonable person think it was appropriate or proper to conduct a strip search of two small children when there has been no outward evidence of any abuse?
Yes, Your Honor. As stated in, for instance, Easy versus Kohler, even the price of one child is too much to pay for trying to uphold this extra level, this traditional level of Fourth Amendment standards. But when we see the statistics, as cited in the lower court, that almost 1 million children last year in the United States were abused, and when a social worker's primary duty is to protect those children, then a social worker who has received allegations and who's heard testimony that there is something seriously wrong going on here, a social worker that makes the search merely enough to verify or deny the allegations, that is reasonable. Now, if she had gone far beyond that search, if she had done other things, that would have been unreasonable. For instance,
well, how much farther could she go?
Well, for instance, Your Honor, in one case that's cited in the record is Franz v. Lyle. I believe it was cited in Calabretta. And they said, well, in this case, the person is denied qualified immunity because of the facts involved. What happened was a police officer received a report that a 2-year-old was running around in dirty diapers all the time. The police officer came to the house and not only investigated the charge of neglect, but also looked for signs of sexual molestation and checked for that, and then took the 2-year-old rather to the hospital. When a search goes beyond what is needed to either verify or deny the allegations, that's when someone should be denied qualified immunity. Here, Ms. Zimmerman just did what was necessary and what she felt was necessary, according to the case law, to verify what had happened and to make sure that those children were safe.
But according to the DSS records, they were devoid. The DSS records have been maintained for 2 years since the time of adoption, and the records were devoid of any reports of abuse or neglect. You have an undated, anonymous letter that states that certain things may have occurred, but doesn't give you any time frame. And in combination, you have a 1-day delay from the visit to the house.
Well, Your Honor, one of the most terrible, fearful things about sexual abuse and child abuse, as many courts have noted, is that it can happen entirely within the context of the home without anyone ever noticing. If a social worker receives even one allegation, and in this case, numerous allegations that something is going on, action must be taken.
Thank you, Counsel.
Counsel?
Mr. Chief Justice, and may it please the court, my name is Faith Ropes, and along with my co-counsel, Christy Ross, we represent the respondent in this case, Mr. and Mrs. William Denoff, and their children, Gabe and Lucy. Your Honors, the Fourth Amendment works to protect both the safety of children
and the freedom of families. Now, in the case before us today, the court has held 3 possible exceptions that are reasonable in nature for the Fourth Amendment. These are consent, probable cause with exigent circumstances, and the doctrine of special needs. I would like to jump immediately to the doctrine of special needs, since that is what petitioner discussed in their speeches. Petitioner relied primarily upon Griffin versus Wisconsin and also New Jersey versus TLO. I would like to first point out to the court that in both of those cases, the reduced expectation of privacy was on account of the fact that the searches took place in a public area, particularly a school. That is not the case before the court today. The search took place inside a private home. We look primarily to Calabretta versus Floyd and encourage the court to look at this as instructional, because there are none other cases in this record that are so primarily similar to the case that's before the court today. In Calabretta versus Floyd, it was specifically stated that nowhere is the protective force of the Fourth Amendment more powerful than it is when the sanctity of the home is involved. I return now to the 3 exceptions that I mentioned, first focusing primarily on consent. In fact, Ms. Summerman did not enter the Danoff household based on consent. In fact, her entry was coercive in nature. If we look to the facts of the record before us today, we would see that the language that is recorded is very coercive in nature, specifically threatening Mrs. Danoff with the removal of her children.
Did she really threaten removal of the children?
Yes.
Didn't all she threatened was to question them at her office, not to take them away from the mother?
Your Honor, if we look, though, to the record, we see that her entire nature was very coercive. She threatened that she could take the children away in her car and did not specify their final destination. In fact, as the Illinois District Court specifically stated in the case of Lynham versus Illinois, that the government's burden of proof applies with great force when a person is threatened with the removal of their children.
Why didn't she just shut the door on her?
Your Honor, we again look to the facts before us today, and Mrs. Danoff was anticipating Ms. Zimmerman's visit specifically because she had forgotten about the doctor's appointment. She was thinking that Ms. Summerman would be coming to her house merely to check up on why that visit had not yet occurred. And if we look to the record...
Sorry. When
Yes,
when the social worker came to the door, didn't she identify to your client that I'm here investigating a possible sexual abuse situation? At that point, couldn't your client have said, I'm not speaking with you?
Well, first, I have 2 responses to that, Your Honor. First of all, she said that she was a child welfare investigator. And secondly, when she came to the door, she did not discuss the alleged abuse, merely stated that she was coming as an investigator, whereas Mrs. Danoff then, after recognizing why Ms. Summerman was attending her home, then asked if her husband and a lawyer could be present, considering the reasoning why Ms. Summerman was then coming. Mrs. Danoff was not aware at the time that there were such criminal charges being investigated in her home, and had she known that ahead of time, she would have prepared and had her husband and a lawyer there present.
But she knew that she had a right to have a lawyer there. She clearly said to the social worker, I'd like to call a lawyer. So at that point, why didn't she politely ask her to leave or call the police if she wouldn't leave and do what she needed to do if it meant calling a lawyer?
Well, Your Honor, I turn to the case that was decided by this court, U.S. versus Drayton, where they specifically said that officers act in full accord with the law when they ask citizens for consent. When this exchange takes place, it dispels inferences of coercion. Now, Mrs. Danoff, when threatened with the removal of her children, acted as any reasonable mother would in light of that threat.
Why? These were not police officers.
Well, that is right, Your Honor. However, when Ms. Summerman came to the door and did so threatened by also stating, do you have something to hide, we contend that Mrs. Danoff didn't even have the opportunity to say no, because she was immediately followed up with the threat of the removal of her children. And as I stated in the Illinois, as the Illinois district stated, Any time that an officer threatens an individual citizen with their removal of their children constitute as coercion of the highest nature. And that is why we contend that there was no consent in Miss Summerman entering the Denolf household.
With regards to this, I don't think the petitioner even mentioned that there was consent ever given. So my question to you is simply this, and I asked the petitioner, what exactly how do you tell me that this is not an administrative search or that there were no extrajudicial circumstances here? Because it sounds like from the facts that there's some serious allegations made, and if you could respond to the petitioner's indications regarding sexual abuse.
Certainly, Your Honor. The petitioner would have you believe that this was an administrative visit specifically because the Denolf family was receiving state aid, and that they fall upon the decision of Wyman versus James that in such cases where there was aid being given, that the state would have a compelling interest to disregard such privacy rights that are laid out in the Fourth Amendment and enter a household. However, this search was not administrative in nature. In fact, we contend that it was criminal in nature. We specifically asked this court to look at the facts, specifically when Ms. Summerman said to Mrs. Denolf, "Do you have something to hide?" The fact that that is in our record seems to point that this search is criminal in nature, not administrative. Ms. Summerman was not visiting the Denolf home simply for the purpose of investigating why she had not met with the requirements of the state. She was visiting for the purpose of determining whether indeed these children had been sexually abused and neglected, which is criminal in nature.
Isn't that implied, though, by the fact that they were supposed to produce the medical certificate?
Your Honor,
Go ahead.
I'm sorry. Your Honor, such a accusation as far as just because they had forgotten a doctor's visit would imply that there was sexual abuse is very, very high. That's a very, very high thing to accuse of.
Isn't it fairly easy, though, to assume that one of the reasons for the medical certificate was to assure the fact that these children were not being abused, among many others probably, but certainly that could have been one of them?
Correct, Your Honor. But we would contend that specifically the fact that a doctor visit had been scheduled and that the requirement would be met, any type of sexual abuse or neglect that was taking place would come to light in that examination by the physician. However,
A lot can happen in 7 days, however.
yes, Your Honor, but I would once again point to the facts of the case that we even have record that Ms. Summerman specifically said in the record that the children were clean, well-dressed, and in good health. If indeed that was the case, we would ask that this court would recognize that a reasonable officer would have allowed a physician to examine the children in the upcoming doctor's appointment, the state's requirements would be met, and the children would be viewed to see whether sexual abuse or neglect was taking place.
But it wasn't done on time. Ought that not to raise some antennas among the social workers?
Well, Your Honor, we certainly agree that just the fact that Mrs. Denolf forgot the doctor's appointment does rise in interest for the state. However, that does not allow them to walk all over the Denolf's Fourth Amendment rights and the sanctity of their home and familiar relations and enter the home and strip search the children.
There was other evidence. There was a letter as well as the neighbors. How do you address that?
Well, Your Honor, we would specifically say that, first of all, the letter was anonymous. Second of all, the reports that they received were very conflicting in nature. And indeed, the state does have an interest in protecting the children. And I would point this court to recognize that...
Just because the neighbors' statements are conflicting, does that necessarily mean that... What does that mean? You're indicating that the statements are conflicting, but how does that discount a statement, or what do I get out of that?
Well, Your Honor, it seems that the state would recognize that if two people happen to offer a conflicting report, something may not be quite right in the reports that were given. Indeed, the safety of the children is...
Excuse me, counsel,
Yes, Your
wouldn't
Honor.
that make it more important to figure out what's happening?
If indeed, Your Honor, the social worker was noticing that these reports were contradictory, we would contend that a reasonable officer would continue searching in other ways that were not such an intrusion upon the Denolf's Fourth Amendment rights.
Such as?
Perhaps interviewing other family members if they consented, or discussing with other neighbors.
While conceivably abuse could be continuing.
Well, Your Honor, we would point to the fact that if Ms. Summerman really
Time.
felt...
Finish your answer.
we would contend that if Ms. Summerman really felt that the children, there was an emergency in their well-being, she would have remained at the household when she believed that there were children inside that were being unsupervised, and waited until she could gain entry into verifying their safety.
Thank you.
Thank you.
Thank you, Counsel.
Counsel?
Mr. Chief Justice, and may it please the Court, my name is Christy Ross, and I will be addressing the qualified immunity issues in our continuing representation of the respondents, Mr. and Mrs. William Denolf, and their children, Gabe and Lucy. Ms. Summerman is not entitled to qualified immunity in this case because of the plain violation of a clearly established right. This can be clearly seen through first examining what qualified immunity is, second, understanding this Court's application of qualified immunity, and finally, examining applicable case law. This Court's doctrine of qualified immunity protects government officials from liability for civil damages insofar as their conduct does not violate a clearly established statutory or constitutional right of which a reasonable person would know. In determining whether or not an official is entitled to qualified immunity, we turn to this Court's decision in Saucier v. Katz, which the opposing counsel laid out for you. The first prong of this test is determining whether or not a constitutional right was violated. The second prong is determining whether or not the right was clearly established. And the third prong is determining whether or not a reasonable officer would have been aware of the establishment of this right. Because knowledge of the law is imputed to government officials, Ms. Summerman should have been sufficiently aware of the judicial precedent regarding her employment. This Court has repeatedly recognized that a basic principle of the Fourth Amendment is that searches and seizures inside a home without a warrant are presumptively invalid, and it is the government's burden to prove that it is not so. In this case, despite the good intentions of the state agents in this case, there's not a reason to abandon this time-tested concept. The Ninth Circuit later expounded on this doctrine of the Supreme Court when they stated that the principle that government officials cannot coerce entry into people's houses without a search warrant or applicability of established exception to the requirement of the search warrant is so well established that any reasonable officer would know it. Now we turn to applicable case law, of which this Court has issued an opinion, and there's many lower courts which uphold this Court's opinion. In the Fifth Circuit's discussion of Roe v. Texas, where they held that qualified immunity should be granted to a social worker who conducted a strip search without a warrant in the home of a Texas girl. However, in their reasoning for this case, they stated that one of the reasons that they granted qualified immunity is because the circuits were split regarding whether or not it was appropriate for a social worker to perform a strip search in that case. However, this Court noted that the Supreme Court cleared up this issue of the lower court's confusion in their case of Ferguson after this fact in Roe v. Texas had taken place.
Is Ferguson in the record?
Yes, Your Honor. As I stated, within Roe v. Texas, they discuss the inter-circuit conflict, and then they discussed that this conflict was dispelled by this Court's opinion in Ferguson.
That was one circuit's decision, however, correct? The Roe?
Yes, Your
It
Honor.
was one circuit's decision, and in that case, as was quoted by counsel for the petitioner, the Fifth Circuit held one way, the Seventh Circuit holds another way, the Third, Ninth, and Tenth hold another way, and the Second Circuit comes down somewhere in between. If that doesn't create an unclear situation, then what does?
Your Honor, that does create an unclear situation, and this Court recognized that and solved the problem with the case of Ferguson. And it was stated in the reasoning of Roe v. Texas, and I quote, that none of the previous courts of appeals to address these issues had the benefit of Ferguson. The Court's recent decision examining dual-purpose searches and the special needs doctrine. In this case, they recognize that the previous circuits, which Your Honor has referenced, did not have the advantage of Ferguson. They did not have a clear doctrine set forth by the Supreme Court by which to govern the social worker's actions. However, today, after Ferguson, we have that record from this court, and we can see that it is clearly established. Furthermore, looking to additional circuits that have ruled on this decision, we can see in other circuits that they have ruled that this is not acceptable. As I stated before, Calabretta versus Floyd entails the entry of a social worker without a warrant into a home, and the social worker conducted a strip search, and the Ninth Circuit ruled that qualified immunity should not be granted because the Fourth Amendment is clearly established, and the social worker should not have entered.
I want to ask you one question about this case that I've asked other respondents throughout the day and through yesterday. Chavez versus Martinez. Why does that case not pull the rug out from under your argument?
Well, Your Honor, the partially because that deals with the Fifth Amendment, and although the Fifth Amendment is equal to the Fourth Amendment, the Fifth Amendment deals with incrimination at the time of trial. The Fourth Amendment deals with the occurrence at the time of the action, search and seizure within the home. In this case...
Everybody gives that as a response, but I don't get why that's important.
Well, in this case, Your Honor, there was a search and seizure within the home, which, as the court has held, that when an unlawful entry or search of the home does not end when government officials walk across the threshold, it continues as they push their will on those residing in the home. Now, in the Fifth Amendment, we have the right of the individuals not to be incriminated by their testimony in court. That's after the fact. Therefore, at the time of this search, their Fourth Amendment rights were violated because an unlawful and unwarranted search was made of the home.
Let me raise one other thing about this case. The case specifically said that there was no criminal prosecution against the gentleman that was involved in this, and immunity was therefore granted to the governmental official. The same is true in this case, isn't it? Your clients suffered no criminal prosecution as a result of this examination, search, whatever we call it, and therefore ought they not to likewise be immune from any liability?
Well, no, Your Honor. The court did hold in Chavez that he was granted qualified immunity, but that was because of his testimony at the time of the trial. Now, our clients, their Fourth Amendment, the violation of their Fourth Amendment rights took place when the government intruded on their home without a warrant. And that is why we would argue that the qualified immunity should not be granted in this case. Now, furthermore, within the discussion in Calabretta versus Floyd, they look at some other cases that apply. Now, first I'd like to turn to some cases that do not apply. Our opposing counsel has cited the case cited in Calabretta of Darrell H. However, in Calabretta's examination of this case, they held that this did not apply because that search took place in a school. Darrell H. therefore should not apply. Also, our opposing counsel has cited New Jersey versus TLO, which also took place in a school. In addition, their case law references EZ versus Kohler. However, in the case of EZ versus Kohler, there were statutory guidelines that specifically addressed the social worker's actions in this case, and therefore her actions were discussed in accordance with those statutory guidelines. Now, turning to the case law that was further discussed in Calabretta versus Floyd, they discussed Good versus Dolphin, in which an anonymous tipster told social services that a 7-year-old girl had bruises on her body and that she, quote, got them in a fight with her mother. As with Calabretta, a social worker and a police officer insisted on entry, claiming that they needed no search warrant to investigate child abuse. They were not granted qualified immunity. Even in the case where there were visible bruises on a girl's body, the unwarranted invasion of a person's private residence is not acceptable, as this court has held and as many lower circuit courts have held. Finally, in the 10th Circuit, in Calabretta's discussion of Franz versus Lyle, they held that a police officer who conducted a nude search of a child lacked qualified immunity for the strip search. In this case, the police officer cited that it was an administrative search. However, the court held that this was not sufficient reason. In light of the fact that this court has clearly established the sanctity of the Fourth Amendment rights, and the Third, Ninth, and Tenth Circuits have all recognized the sacrosanct nature of the Fourth Amendment rights, Ms. Summerman should not be granted qualified immunity for violating these rights.
Hold on, you told me there were three, in Saucier, there were 3 points, and I really want you to touch on the legitimate justification in regards to the officer doing what she had done. Could you finish that for me?
In dealing with the third prong, determining whether or not a reasonable officer would have believed his actions to be acceptable?
Yes, please.
If I'm running out of time, may I
Go
answer
ahead.
the question?
Yes.
All right. A reasonable officer would not believe that their actions could be acceptable in light of this court's jurisprudence and also in light of the facts that various circuit courts have also ruled that strip searches and unwarranted invasion of a person's private residence are not acceptable under the Fourth Amendment. For these reasons, we believe that because Ms. Summerman entered without a warrant, and the case law is clearly behind the respondent in this case, that a reasonable officer could not have believed that this invasion was constitutional. Does that sufficiently address Your Honor's question?
If that ends your argument.
All right. We urge this court to uphold the lower circuit's court and grant the denulves their Fourth Amendment rights.
Thank you.
Thank you, counsel.
Counsel?
May it please the court. I wish to address several inaccuracies in the petitioner's argument that have been suggested to the court. First is the idea that Griffin did not, the idea that Griffin took place in a public area. Griffin actually took place in a home. It was a search of a petitioner's home. That is why we believe that it can be looked to when we're talking about a special needs search within a home, since that's the same situation there. Secondly, Mrs. Denulf did know that there was a charge of possible sexual abuse. That's explicitly stated in the record. However, Ms. Summerman did not know that a doctor's appointment had been scheduled. The record does specifically say that a doctor's appointment was scheduled, but the record never says that this was told to Ms. Summerman, which explains a lot of her actions after that. So it cannot be said that Ms. Summerman should have had this omniscient knowledge that an appointment actually had been scheduled and used that in the pursuit of her actions. But most importantly, the Fifth Circuit did not resolve the problem here. The Fifth Circuit said that they are taking sides in an inter-circuit conflict, and that the way they're taking sides is by looking at Supreme Court cases in a certain way.
Was that Roe?
That is in Roe, yes. Roe specifically said they are taking sides. This is not a resolution of any sort, and a reasonable person would not look at this as a resolution. Moreover, respondent relies almost exclusively on cases cited in the Ninth Circuit court case, which, as Roe said, is a court that's come down on one side of this argument, but that's the only circuit that has ever denied qualified immunity to a government worker when it comes to the social welfare context. If we look at, for instance, the Seventh Circuit in Doe versus Heck, qualified immunity was granted, mostly because of the confusion. If we look at the Fifth Circuit in Roe, qualified immunity was granted because of the confusion. If it's true that Ferguson simply cleared all this up, then we don't see why in the world Roe would still grant qualified immunity to the person involved in their case. Finally, the main thing that we see here between the circuits is very similar to the bickering neighbors. One neighbor sees the facts in a certain way, the other neighbor sees the facts in another way. And the respondent specifically stated that, well, if there are contradictory reports, then you really can't take either side. Well, of course the court here has to take a side. But the fact is, Ms. Summerman should not be proactively punished for deciding which neighbor she was going to believe or which side in this inter-circuit conflict she was going to believe, and then the court later saying, actually, you picked the wrong side because we believe it's this. We believe that Ms. Summerman is on the right side, but even if she is not, the fact that she has chosen a side in the exercise of her discretion as a social welfare worker to protect children should not be punished.
That somebody's seeking to punish her? This is a civil suit, not a criminal case.
Well, Your Honor, this is a suit for damages. That is where qualified immunity comes in, and she would be actively punished. Not only that, but other social welfare workers around the country would take this as a cue that they must be very, very careful with their actions, and even more child abuse would likely occur.
So you're saying she's being punitive because of punitive damages?
That is the primary reason. That is why qualified immunity is involved, and that is one of the primary reasons why qualified immunity should be granted.
But if there's strictly a lawsuit based on liability and for regular damage as opposed to punitive damages, she's not being punished per se.
Time.
May I answer the question, Your Honor?
Certainly.
Your Honor, in any case, Ms. Summerman is being punished. If this court rules that she is incompetent or knowingly violated the law, that is punishment alone, but she is also being sued for damages that she or the state will be liable for and that will infringe other social welfare workers' efforts in the future. Thank you.
Thank you.
An excellent job by everybody. If we could ask everyone to step outside for a moment.
Why don't we
go
Why
out?
don't we go out?
Yeah.
I mean,
Why move
7
them
of
out?
us.
You can sit tight.
Don't move them out.
No, that one, no.
Let me again thank everybody for competing this weekend. You all did a super job. We were very happy to have you here. I want to give a special thank you to FATV for broadcasting the final round, and a special welcome to Buddy Ramberg and all of our viewers on FATV. I'm going to turn it over to the court, who's going to announce their decision, and then we'll bring both teams up to give them their awards and congratulate.
First of all, I'm speaking for everyone when I say you all did a great job, and you two especially in this round. I have to say you made it very, very difficult for the last several rounds for us, for judges, regardless of whether it was us or whoever, to decide. I have to also tell you that this round was very, very close. It was split decision, but somebody has to win and somebody has to come in second. Not lose, but come in second, because there are no losers here. You are all a very, very impressive group of students, and you've done your schools proud and yourselves proud.
School.
Every participant, and this is one of the highlights of my year, to be able to be a judge at this event. Thank you for giving me the opportunity. Now, enough BS. Let's get to the nitty-gritty. We have decided that Rael Papke and Matthew Dumais won the round, but it was very, very close. And Matthew, I want to commend you especially.
We'll bring Christy Ross and Faith Brooks up to get their heads in front of them. And now our champions, Rael Papke and Matthew Dumais. And of course, if we could bring President Ferris up to get the school's trophy. Thank you all for coming. Hope to see you again next year.
You want this?
Mike, get a picture with you and your 4 students, maybe over here. Good job.